Hey everyone, welcome to Judgment Digest. Today we will be going to study about the most important case of CPC as well as of interpretation of statutes. So this case becomes very important when you read section 89 of CPC. Along with that, if you read the subject of interpretation of statutes, so while for the purpose of interpretation, this case teaches us a lot of things. So now, first, we'll understand what happened. Now, I'm not going into the facts of the case, but what was the defaults that was there in this case to which the Supreme Court had made interpretations and also rectified those errors in such a way so that a a purposive construction can be done. The meaning, the true intent of the legislature can come out, and the object of section 89 can be fulfilled. So in such a beautiful way the court has interpreted this section 89 in this particular case. So now first we will see what are the anomalies in this case that exist in section 89. So in section 89 CPC. So the first thing that was there was mixed. I'm so sorry. The first thing was there was mixed definitions. Right. If you look at section 89 subclause 2, clause C and clause D. Okay. So the generally accepted definition of two things seemed to be interchange. One was judicial settlement and other was mediation. This was given in section 89 subclause 2 subclause C, and this was given in section 89 subclause 2 subclause D. So whatever the general definition of judicial settlement and mediation was there, is accepted throughout, was not given properly in these two sections. So basically when you read the earlier these sections, you will find that what is mediation, the definition of mediation is given in this section, and definition of judicial settlement is given in this section, right? So this was the first first error that was there in section 89. Now moving on, before we'll move on to what the court had decided, first we'll see all the difficulties. So what was the second? Second was that there was unrealistic court role. Now this section 89, what it said was that the court has to frame terms of settlement. Terms of settlement. Now if you know the meaning of terms of settlement, it is basically when you go for some out of court settlement. This term of settlement is made when both the parties generally mutually agree to something. Mutually agree to this terms of settlement is made because they have settled their matter, right? They have mutually settled their matter for which terms of settlement is made. But in this section, what the section stated was that while the court is referring the matter to for the out of court settlement for any of the ADR mechanisms, the court has to formulate this terms of settlement. So you just think, okay, how before hearing the parties, how can someone frame the terms of settlement, right? If you want to come to a final conclusion, you need to hear both the parties, the petitioner and the respondent. Then only you can come at a settlement, right? So without hearing, how can court come to a terms of settlement? So this was the another error that was there in section 89, right? Now moving on to third. third is very much related to this earlier one. How come? It was, as I've already told you, when the court refers this matter, when the court is referring the matter for ADR settlement, for ADR mechanisms, now the section states that court has to formulate terms of settlement, right? So in this thing, one another default is there, that why do court will frame terms of settlement. The duty of the court is, duty of court is to adjudicate based on merits of the case. If the court starts to just, hear the matter, or without hearing the matter they start formulating terms of settlement, that is not the job of the court, right? That is not the job of the court. The job of the court is to adjudicate the matter. So this was another issue, that terms of settlement is always framed by mediator or conciliator, but not by the judge. It's their job, it's not the judge's job to do. So this was the third error that was there in section 89. Due to all these errors, there was a requirement that this section should be amended, right? Now we will see what judges, the court, interpreted in section 89 decision, or we can say what was the interpretation was made. Yes, now we'll look into the interpretation. So the first thing that was there is, I told you the first default. What was their first error? You can see first error is mixed definition, that the definition was seemed to be interchanged. So what the court said in their first decision was that the definition of what? Definition of clause C and clause D should be interchanged so as to give it a universal accepted definition of judicial settlement and mediation. Okay, now what was the second thing? What was the second default? See, unrealistic court role. So basically the role of the court is not to frame the terms of settlement. So I will this second and third dispute I will tell error I will tell you together. What was the first one? The court role is to adjudicate and not to frame terms of settlement, right? So because the court's job is not to frame the terms of settlement, what the court said, that the term, this phrase, terms of settlement, will be now read as summary of dispute. So now both these errors were solved together, as the court said that our job is not to frame terms of settlement. We can't frame terms of settlement without hearing the parties, right? So what we will do is, we will from instead of reading as the phrase terms of settlement, we will now read it as summary of disputes. So the court said that in section 89, wherever it is written that terms of settlement, the frame terms of settlement will now be read as summary of disputes. So whenever the court will refer the matter to any of the ADR mechanisms, now they will not frame terms of settlement. They will not have to frame terms of settlement without hearing the parties. Rather, now what they have to do is, they have to just frame the summary of dispute and have to refer the case to ADR mechanism. Okay, so now two errors are resolved. That the first is, the court's duty is not to frame terms of settlement, so that is resolved. Secondly, this terms of settlement is now read as summary dispute. So without hearing the parties, it was unfair to frame terms of settlement. Now the court has given it a purposive construction, a purposive interpretation, so that the object of this section 89 as well as the object of ADR mechanisms is now fulfilled. It will further the object of both the things, right? So this was another point that the court referred. Now, one more thing was there, one more default I would say was there, that was कि whether, this was one of the issue, कि whether section 89, whether the parties are forced under section 89 for ADR mechanisms for out of court settlement. So why this issue arose? This issue arose because when you read section 89 together with order 10 rule 1a, then the combined reading of these will give an impression that ADR is mandatory. The court in this case said that the actual reference, I will tell you the difference here. The court said that if any civil case is coming to you, right? If there is any civil case, example, if you have any civil case, the consideration is mandatory. What do you mean by consideration? Means you have to check whether this case is fit for ADR or not, whether this case can be settled through out of court settlement or not. So they have to just do a check, a quick check, right? A quick check that they have to do. So reference is not mandatory, but this consideration is mandatory. You have to check whether the case is fit for the ADR or not. If it is fit, if the case is fit for ADR, if it is fit, then the reference is also mandatory. Is also mandatory in this case. But if it is not fit, then reference also is not mandatory. Okay, so this is where you have to check whether the case is mandatory, whether the case can be referred for ADR or not. But apart from this, you have to see that not the consent. The very important thing is consent. Even if the case is fit, even if the case is fit for ADR, you have to very much remember this. Even if the case is fit for ADR, you have the consent of both the parties. Consent of both the parties are mandatory. If even one of the parties declines that they don't want out of court settlement, this cannot be done in that case. The reference cannot be made in that case, right? So now, as I have told you that consent is very much important, but that thing is also different in different mechanisms of ADR. So when we talk about arbitration, in arbitration, consent of both parties is required. Mandatory. Plus, consent is mandatory, plus once the reference is made, the case goes beyond the control of beyond the control of the court. So anyhow, this arbitration, this in this arbitration, the award has to be passed. The arbitrator cannot say that the dispute is not being settled, so we are referring the case back to the court. No, this cannot happen in arbitration. Okay. So basically, the consent is important, and once the case is referred, it cannot be referred back to the court. Right. Next is conciliation. Conciliation. Now, what happens in conciliation? In conciliation, also the consent is mandatory. Consent is very much mandatory, but once the reference is made, if the case is referred, it can be sent back to the court. Mind it. If the settlement is not made, the case can be referred back to the court, right? So in this case, the case does not go beyond the control of the court, right? So consent of both the parties is necessary, but the case does not go beyond the control of the court at all. Okay. Now next is mediation. Mediation. In mediation, consent is not always necessary. Is not always necessary. So basically, the court sees the kind of dispute. The courts look into the nature of the dispute. If the court finds it that yes, the case is fit for ADR, and this case can be referred to out of court settlement, and the case is of such a nature that it can be resolved through out of court, easily resolved by out of court settlement, that court can refer the matter to any of the for mediation even without your consent. The court can refer the matter to mediation even without your consent. So consent is not always necessary. The court looks into the nature of the dispute, plus the court looks into the nature of the dispute, plus it looks into the legislation. For example, your dispute is related to consumer protection, right? Your dispute is related to consumer protection. Now when you see the consumer protection rules 2023 and you read it with Consumer Protection Act, you will find that mediation is necessary. Mediation is necessary in that case. So there are stances where the legislation itself has mandated the mediation. So therefore, in these circumstances, the consent is not required and the legislation is followed, and your case is referred to mediation without your consent. And the example includes consumer protection, family disputes, labor disputes, etc. Okay, this was all about mediation. Then there is something called judicial settlement, as we have already seen it into judicial settlement. Judicial settlement is where also consent not mandatory. Okay, so here it is not writing, I'm sorry. So consent is basically not required, not mandatory, and court can refer your dispute without your consent. And it is same for Lok Adalat also. Okay, So this was, we are talking, I will give you a quick recap at last, because I know there are so many concepts involved in this case. There are so many things that was discussed in this case, in this particular case. So this was the last thing, that Lok Adalat also does not require, for reference to Lok Adalat, the consent is not mandatory. Okay, so this was all about consent part. So I will not go much into implementation. There was many other things that was discussed in this case, but for now that is not important. It is just that implementation also was discussed in this case, but I'm not going deeper into it, because implementation is also, somewhere or else. For implementation also, the when the award or decree, oh sorry, award is passed by any of the out of court settlement, so you need to file an application to the civil court, the court that has referred your matter. And when you will make the application, that court will make a decree. And when that decree will be passed, then it will be executed in a manner that a normal decree is executed. So that is so many other things that were discussed in the case, and I'm not going into it. This was implementation, enforcement was just the example that I said just now. So we'll take a quick recap. Okay, quick recap so that you do not get confused into it, right? So we started with the anomalies part. We started with anomalies. We saw that there were various mixed definitions of judicial settlement and mediation, and the court said that you will be interchanging those things. Then we saw that the phrase terms of settlement. The court cannot frame terms of settlement without hearing the parties, right? So what the court said, also the job of the court is to adjudicate and not to frame terms of settlement. That is the job of the mediator. So what the court said, from now on we will read terms of settlement as summary of disputes. So instead of framing terms of settlement while we will be referring the case to ADR, we will be framing summary of disputes. So the phrase terms of settlement was interchanged with summary of disputes, right? So this was the things. Then we discussed whether the parties are the parties can be forced under section 89 to go for out of court settlement. We saw that generally no, the court cannot force the parties to go for out of court settlement. Even if one of the parties is declining, then the court cannot force. Okay, so for that we saw that consent is required. It cannot be uh, like that be referred, the matter cannot be referred like that. And also we have seen that uh, the reference is not mandatory, rather consideration is mandatory. You need to check कि ये case आया है हमारे पास, and whether ये case is fit for ADR, can this case be resolved through ADR mechanisms or not. You have to check that. And if it fits, if you as a judge thinks that this particular case can be resolved through ADR mechanisms, then you are bound to refer that case to ADR mechanisms. But if you feel that this cannot be solved through out of court settlement, then you are not forced to refer. Rather, you just have to record the reasons that why it cannot be settled through out of court settlement. Just that. Then we have looked into the part of consent. We have seen that consent is not important, even if the consent of both the parties are important, and even if one is declining, it cannot be referred, the matter cannot be referred. But this is different in different kind of ADR mechanisms. So we have seen that in case of arbitration, consent is not consent is mandatory. Consent of both the parties is mandatory. Even if one of the parties is saying that we don't want arbitration, the court cannot refer the matter for arbitration. Also, if once the court has referred the matter, the case goes beyond the control of the court, and court cannot take the case back to itself to adjudicate, right? Next is conciliation. In this also the consent is required, and in this, once the case is referred, if the settlement does not take place, the case can be referred back to the court for further trial. Then we have mediation. In mediation, consent is not always necessary. It depends upon the nature of the dispute that consent is required or not. Also, if legislation mandates that consent is not necessary and you have to send the case for mediation, then the consent is not taken and the case is directly referred to mediation. Similarly goes for conciliation, similarly goes for judicial settlement and lok adalat. So this was the case of this was the Afcon case, and various concepts of Section 89 was discussed in this case. And if you read this case throughout, you will get to know that this case is very much important for the interpretation perspective. If you are trying to learn how the interpretation is done, how the statutes are read, how each word is to be understood, interpreted, construction of that statute is done, a purposive construction is done. If you want to learn that, you can read this case. This is very, very, very important case for these two matters, for Section 89 for arbitration and for interpretation of statutes. So, thank you for listening so patiently. Thank you so much for watching till the end. I'm really happy that you guys watched it till the end. And guys, trust me, if you'll read this case, you'll get to know very much, many things. So, okay, we'll meet in next video with more such informative videos. Thank you so much. Thank you.